Amendment 11. Suits against states. Passed by Congress March 4th, 1794. Ratified February 7th, 1795. The 11th Amendment changed a portion of Article 3, Section 2. The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. Common interpretation. The 11th Amendment by Bradford R. Clark and Wilkie C. Jackson. The 11th Amendment's text prohibits the federal courts from hearing certain lawsuits against states. The amendment has also been interpreted to mean that the state courts do not have to hear certain suits against the state if those suits are based on federal law. During the debates over whether to ratify the Constitution, controversy arose over one provision in Article 3 that allowed federal courts to hear disputes between a state and citizens of another state or citizens or subjects of a foreign state. And the Federalists who generally oppose the Constitution feared that this provision would allow individuals to sue states in federal court. Several prominent Federalists who generally favored the Constitution assured their critics that Article 3 would not be interpreted to permit a state to be sued without its consent. However, some other Federalists accepted that Article 3 permitted suits against states, arguing that it would be just for federal courts to hold the state accountable. Soon after ratification, individuals relying on this clause in Article 3 to sue several states in the Supreme Court. One of these suits was Chinholm versus Georgia, 1793, in which a citizen of Southern Carolina, Chisholm, sued Georgia for unpaid debts incurred during the War of Independence. Georgia claimed that the federal courts were not allowed to hear suits against states that refused to appear before the Supreme Court. In 1793, the Supreme Court ruled by a 4-1 vote that Chisholm's suits against Georgia could proceed in federal court. The court, relying in part on the text of Article 3, explaining that between encompasses suits by and against a state. Several other suits against other states were pending at the time Chisholm was decided in 1793, including Wausau versus Massachusetts, in which a British subject, William Wausau, sued Massachusetts for violating the treaty peace by confiscating his property. Alarmed by the Supreme Court decision, in Chisholm, Senator Killam Shrum of Massachusetts quickly proposed an amendment that ultimately became the 11th Amendment. As ratified, the amendment provides the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. Following its ratification, pending suits against states were generally dismissed. In some early interpretations, the amendment was not read expansively. In Cohens v. Virginia, 1821, the court rejected a challenge to its jurisdiction to review a state court decision in a criminal case in which Virginia prosecuted two brothers from Virginia for the crime of selling lottery tickets. The Cohen defended on the ground that a federal statute authorized the lottery and ticket sales. The court first concluded that as the Constitution originally stood, the appellate jurisdiction of this court in all cases arising under the Constitution, laws, or treaties of the United States was not arrested by the circumstances that a state was a party. Turning to the 11th Amendment, the court noted that a defendant who seeks appellate review of an adverse decision does not commence or prosecute a suit against the state. Moreover, the court said the amendment would not in any event apply because the Cohens were citizens of Virginia, and thus their appeal against Virginia was not by a citizen from another state or by a citizen or subject of any foreign state. Its 1890 decision in Hans versus Louisiana, the Supreme Court interpreted the 11th Amendment immunity broadly to prohibit suits against the state not only by citizens from another state, but also by a state's own citizens, and in cases arising under federal law. It essentially disavowed the country language in Cohen's. The Hans Court placed weight on the speed with which the amendment was adopted, and said that Chisholm and erred in upholding jurisdiction under the original Constitution, which could not have contemplated individual suits against states. As the Congress in the 20th century increasingly enacted regular legislation that applied to the states, question arose about whether federal statutes could be enforced against states through suits in federal court. In Fitzpatrick versus Bitzer, 1976, the court held that Congress could subject state to suit in federal courts through laws enacted under its 14th Amendment power to address discriminatory state action. In Pennsylvania versus Union Gas Corporation, 1989, 5 justices voted to allow Congress to subject states to suit under the Superfund Act, enacted under Congress Article 1 power to regulate interstate commerce. There was no majority opinion, however. The court quickly reversed itself on this issue. In Seminole Tribe versus Florida, 1996, the court issued a majority opinion for 5 justices, holding that the Congress lacked power to subject states to suits when legislated under its Article 1 Commerce Clause powers. Since Seminole Tribe, the court has reaffirmed this holding, and for the most part, has limited Congress' ability to subject states to suit in federal court, unless Congress acts pursuant to its power to enforce the 14th Amendment, in part on the theory that it was adopted after the 11th Amendment, or for some bankruptcy issues. The Supreme Court decisions for state immunities from suit that appear to go beyond the terms of 11th Amendment. For example, as noted, suits by individuals against their own state have been barred. Suits by foreign states are also barred. The court has first held that states enjoy immunity in state court from its suits based on federal law. Alden versus Maine, 1999. Moreover, states may consent to suits that appear to be barred by the amendment. The decision says that the court may regard state sovereign immunity, the legal privilege by which the state government cannot be sued, at least in its own courts, without its consent, as an underlying constitutional postulate, an assumption reflected but not fully captured by the words of the 11th Amendment. At least 3 other approaches have attracted support. First, some argue that the 11th Amendment should be applied according to a simple literal reading its text to bar suits against states by other state citizens and the foreign citizens or subjects, but not by these parties, even if their claim is based on federal law. Others have argued that the 11th Amendment language tracks a party-based head for jurisdiction that should not be understood to prevent federal courts from hearing suits against a state by citizens of another state if the claim arises under federal law. Still, a third view regards the 11th Amendment as addressed to the courts, prohibiting them from construing Article 3's jurisdictional grants to abrogate a state common law immunity, but allowing Congress to override such immunity if it clearly expresses the intent to subject states to suits. The accompanying commentaries present further scholarly views. While the states continue to enjoy broad sovereign immunity from suits, the Supreme Court does allow suits against state officers in certain circumstances, thus mitigating the effect of sovereign immunity. In particular, the court does not read the amendment to bar suits against state officers that the court ordered to prevent further violations of federal law. Moreover, suits by other states and suits by the United States to enforce federal laws are also permitted. The 11th Amendment is thus an important part, but only a part of a web of constitutional doctrines that shape the nature of judicial remedies against states and their officials for alleged violations of law. Mander's debate. The first perspective. The 11th Amendment, a textual approach by Branford R. Clark. The 11th Amendment arose out of a dispute and began during the ratification debates over the meaning of Article 3 of the original Constitution. Article 3 provided that the judicial power shall extend to controversies between a state and citizens of another state and between a state and the foreign citizens or subjects. Critics of the Constitution and the Federalists read this state-citizen diversity provision to permit citizens of one U.S. state or of a foreign state to sue another U.S. state in federal court. Proponents of the Constitution, Federalists, assured critics that the Constitution would not permit this individual to sue states in federal court. Based partly on these assurances, the states ratified the Constitution in 1789. When the Supreme Court read Article 3 to permit a citizen for South Carolina to sue Georgia in federal court, Chinholm versus Georgia, 1793, Congress and the state moved quickly to adopt the 11th Amendment, which provides the judicial power of the United States shall not be constrained to extend to any suits in law or equity, commenced or persecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. As written, the 11th Amendment appeared to prevent federal courts from hearing any suits by an out-of-state or foreign citizen against state, but does not prevent federal courts from hearing suits by citizens against their own states. Nevertheless, over time, judges and commentators have sought to expand or contract the state's immunity from suits under the amendment. The Supreme Court famously went beyond the amendment text in Hans versus Louisiana, 1890, by prohibiting a citizen of Louisiana from suing Louisiana in federal court. Conversely, starting in the 1980s, some dissenting justices have urged the court to narrow the amendment text by allowing federal court to hear suits against a state by citizens of another state if the claim arises under federal law. Both of these readings, the 11th Amendment, contradict the text. The proponents of both readings seek to justify their preferred departure from the text by pointing out that applying the text as written would draw an arbitrary distinction between in and out state citizens. They argue that it makes no sense to bar out state citizens from suing the state while allowing in-state citizens to do so. While agreeing that this disparity creates a problem, they disagree on the solution. One group would expand the 11th Amendment immunity and the other group would narrow it. The apparent anomaly created by the text disappears, however, when one considers the 11th Amendment in historical context. Those who ratified the amendment would not have understood the text to create any disparity between in and out state citizens because they did not understand the Constitution to authorize any suits against any states by any citizens. Some background is helpful. Under the Articles of Confederation, Congress could regulate states as opposed to individuals, but had no power to enforce its commands. Not surprisingly, states often ignore Congress's commands. And the Constitutional Convention, the Virginia Plan, proposed giving Congress power to use military force to coerce states to comply with the federal commands. This proposal was widely criticized on the ground that it would lead to a civil war. It was not adopted. Instead, the Constitution gave Congress power to regulate individuals rather than states, thereby enabled the federal government to enforce a command against individuals without confronting states. This issue was of essential, but largely forgotten, significance to the Constitution adoption. Congress originally charged the Philadelphia Convention with merely amending the Articles of Confederation, but the Convention concluded that it could not save the article without authorizing the use of force against states and thereby risking a civil war. Thus, when the Convention proposed an entirely new constitution, one of the first questions asked by skeptics was why the articles could not simply be amended. Prominent Federalists explained that the new constitution, regulating individuals rather than states, was necessary to avoid authorizing coercive force against states. As Alexander Hamilton explained, the federal government must be funded as to the object committed to its care upon the reverse of the principle employed by the articles. In his view, we must extend the authority of the Union to the persons of citizens, the only proper object of government. This change, he explained, would eliminate the need for coercion of arms against states and rely instead on coercion of magistracy against individuals. Federalist number 1516. Many found these arguments persuasive until anti-Federalists pointed out that Article 3 of the proposed Constitution could not be read to authorize suits against states in federal court. They argued that if Article 3 authorizes such suits, then Congress would have power under the necessary and proper clause to enforce any resulting judgment against states through force if necessary. On this reading, Article 3 directly contradicted the Federalist claim that the Constitution was preferable to the article because it avoided reliance on coercive force against states. Federalists like Alexander Hamilton, James Madison, and John Marshall responded by denying that Article 3 should or would be read to authorize suits against states. They argued that the relevant provisions of Article 3 shouldn't be read only to permit a suit by states, based in part on these assurances, the Constitution was adopted. When the Supreme Court subsequently read Article 3 to allow Chisholm, a citizen of South Carolina, to sue Georgia in federal court, Federalists and Anti-Federalists united to amend the Constitution and restore their preferred understanding Article 3. The text of the 11th Amendment reflects this shared goal. The amendment did not propose to change the Constitution, rather it sought to restore the preferred construction of Article 3, judicial power. This is why the amendment states that the judicial power shall not be construed to extend to the prohibited suits. This kind of amendment was known as an explanatory amendment because it merely sought to explain or correct a misinterpretation of a pre-existing legal text. The amendment did not attempt to explain any other portions of Article 3 because the citizenship diversity provisions of Article 3 were the only provisions that anyone ever suggested could be construed to permit individuals to sue states. In any event, the amendment's prohibition against extending the judicial power to any suits with the proscribed party alignment necessarily cut across all heads of Article 3 jurisdiction, including jurisdiction over cases arising under federal law. This was important because the author of the amendment, Senator Schrum of Massachusetts, undoubtedly made it to bar the pending case for Warsaw versus Massachusetts from proceeding in federal court, even though the plaintiff was seeking to enforce the treaty peace. In sum, because the 11th Amendment made sense as written when adopted, the Supreme Court should follow the text of the amendment today and reject calls to expand all contract, its specific terms in favor of broader constitutional values. For further elaboration, see Bradford R. Clark, the 11th Amendment and the Nature of the Union. Next perspective, a narrow repeal of party-based jurisdiction by Wilkie C. Jackson. Some forms of jurisdiction authorized by Article 3 of the Constitution are based on the parties. Others are based on the subject matter. The 11th Amendment is best read as a specific appeal for a party-based grant for jurisdiction originally found in Article 3. The amendment withdraws jurisdiction of federal courts over any suits in law equity against one of the United States or by citizens from another state or by citizens or subjects from any foreign state. It thereby repealed part of the jurisdiction originally given in Article 3 over controversies between a state and the citizens of another state and between a state and the foreign citizens or subjects. Properly read, it should pose no constitutional barrier to suits against state under federal law, in Article 3's words, to cases arising under this Constitution, the laws of the United States, and treaties made under their authority. If the 11th Amendment were intended to protect the states from all liability in suits by private parties, as Hans v. Louisiana suggested in 1890, is poorly drafted to do so. There would be no need to recite that the citizens of other states and foreign states are party barred. Instead, the technical language of the amendment tracked the language of the state party-based head of jurisdiction Article 3, suggesting it was narrowly targeted and removing the specific basis for jurisdiction under which the court decided Chisholm versus Georgia, 1793, and under which all then pending suits against states, including Massachusetts, appear to have been brought. Supreme Court decision closer in time to its adoption treated the amendment as narrow in scope. For example, in Osborne versus Back of the United States, 1824, the court explained that the 11th Amendment should apply only where the state itself is named as a party. It did not constrain jurisdiction over state officers in action to recover money due the back of the United States. In the late 19th century, the court began to expand the amendment's application. Today, the court raised amendment to bar suits against state officers to recover money owned by the state. When the Constitution and the 11th Amendment were adopted, there was uncertainty, reflecting a set of questions not fully answered about the scope of judicial power, especially over cases arising under federal law. Disagreement over whether a state was suitable under Article 3 at the time of ratification was noted in our joint statement, for example. Edmund Randolph, a member of the committee of detail that played a key role in drafting the Constitution and the supporter of ratification, argued in the Virginia Ratifying Convention that a state could and should be subject to suits under obligations. In the drafting of the 11th Amendment, broad and narrow proposals were rejected in Congress, leaving room for scholars to disagree about their import. This uncertainty in founding intentions suggests that we should let the Constitution's words and its basic structural assumptions be our guides. The important structural principle that is judicial power must be coextensive with the legislative power expressed in the Federalist Number 82 by Alexander Hamilton. In the Virginia Ratifying Convention by James Madison and in foundational decisions of Marshall Court, the present court interpretation of the 11th Amendment and limiting the judicial power in areas in which Congress can validly legislate is inconsistent with this principle. Another basic principle is that the Supreme Court has jurisdiction to review decisions of state courts routinely acting upon and providing matters to the states, although arising from a dispute between private parties. Martin versus Hunter's, let's say, 1816 is instructive. There, the Virginia courts refused to comply with the earlier Supreme Court order, arguing that appellate jurisdiction over the state courts was inconsistent with the spirit of the Constitution, which was never designed to act upon state sovereignties, but only upon the people. The court unequivocally rejected Virginia's argument. It's a mistake that the Constitution was not designed to operate upon states in their corporate capacities. It's crowded with provisions which restrain or annul the sovereignty of the states, containing a long list of disabilities or prohibitions imposed upon the states. Of course, the United States can review the proceedings of the executive and legislative authorities of the states, and if they are found to be contrary to the Constitution, may declare them to be of no legal validity. Surely, to exercise the same right over judicial tribunals is not a more dangerous act. Not only did the Constitution impose obligations and prohibitions on states, it also gave the Supreme Court jurisdiction to resolve controversies between two or more states. Under 11th Amendment doctrine, there is no immunity from suits by the United States or by sister states. Coercive judicial power in such cases was plainly contemplated. Although the Convention did not adopt proposal to authorize use of armed forces specifically against states, this does not mean that it abandoned the national power to impose legal requirements on the states. Rather, the Constitution ended to the powers of the national government the powers to regulate and tax individuals directly, because doing so would work better than trying to compel the state to do so. The court has held that the Constitution prohibits commandeering of states so as to require them to regulate private persons, while upholding federal laws that apply coercively to the states in a wide range of areas: environmental law, minimum wage, and medical leave laws. The anti-commandeering law is narrow. It does not preclude regulation of states by federal law, but rather it precludes federal mandates to the states and the government to regulate private persons on behalf of the federal government. This principle does not support the claim that the framers and ratifiers of the Constitution under the 11th Amendment would have wanted Congress to have the power to require states, for example, to pay the minimum wage, but disallow Congress from the best will of enforcing that obligation through suits for damages by the individuals affected. No interpretation of the amendment as applied to cases arising under federal law is fully satisfactory, although there are powerful reasons to regard the amendment as irrelevant to federal question jurisdiction. The literal text amendment could be read to preclude the armed state and the foreign citizen from suing state for any claim. But the more expansive reading of the amendment was not consistent with the basic constitutional principles. Using this narrow technical amendment to prevent the U.S. Congress, in which all states are represented, from deciding to allow citizens to sue states that violate the rights under one federal law is a mistake that undermines broader constitutional principles. For elaboration, see Wiki C. Jackson, the Supreme Court, the 11th Amendment, and the State Sovereignty Immunity. It's published by Yale, and the Federalism, the uses and the limits of law, published by Principle, this in Harvard Law Review, 1998. Okay, that's conclude this one.